Next time, I'm so thankful for inviting me. It's a great opportunity for me to share my views on the topic that we have been discussing since yesterday. Because so much of theory has been already discussed, I'm not going into that. And as a lawyer, because what we discussed is when put into practice has issues when it comes before the court, how the court is reacting or how with that issue we are approaching the court is what I am going to share with you all. And before I start, as a young lawyer, you're all going to be lawyers. When I entered first time to the court, I saw a writing, be howsoever high you may be, the law is above you. It really fascinated me in those days. But with few months of my practice, I realized that that means that everyone is equal before the law. But in practice, some are more equal, some are less equal, is what I understood. And with that understanding, as I have been an activist in civil liberties organization as a law student, and we dealt many, I have filed cases and some of related to the topic which we are discussing. I confined to that, and because we are speaking about the dignity, dignity, it has different meanings and different different situations with different people. Where when they face and they face a problem, legal problem, when they approach the court. The first case I would like to discuss with you all is that it was a 10 years long legal battle. Recently, judgment is also passed. A young couple approached me who got married, who are belonging to different religions. When they want to join their baby in school admissions, because they are belonging to, one is to Hindu and another is a Christian, they want to bring up their children without any religious influence on them. Outside the religion they want to bring up. And they are, not they both, but husband is a non-believer and wife, though she is a believer, but she too agreed to bring up their children in an atmosphere of no religious influence are there on them. So when they went to the school admission, in the admission form they are asked to fill up the religion of the parents. They put there no religion before the religion column and no caste before the caste column. Then the school admission, they rejected their application. Before rejecting, they said that if you are not, as father, not willing to write this, at least you give your wife's religion. Then he said that we both are decided. Then they said that we cannot help it. The rules are saying so. So we have to follow the rules. We will not give admission. He approached first to the Human Rights Commission, SHRC, State Human Rights Commission. In the Human Rights Commission, what they passed an order is to the authorities, that the education department, to follow the law in work. The law is that every admission forms invariably they have to fill that it's a fixed format. So they have to give the religion name. So for those who doesn't believe religion, who are religious, what they have to do? And then that matter has come before me to file a writ petition. I filed a writ petition when the child was 3 years old. Interestingly, I got an interim order in admission stage itself, observing that right to practice religion under the Constitution means right not to practice also. It is a fundamental right. So interpreting that, an order is given to as an individual relief to the baby to admit in the school. And then my friend got that this is not a problem for me only. It is a problem for many of the couples who are with this kind of ideology. So their identity, here comes the identity of their, is a forced identity is being given to them. By looking at their names, they themselves fill up. And it's not at the stage of school admissions, even at the stage of giving birth certificate by the registrar of births and deaths register. And even at the stage of at different stages, it comes up. And in the census also. In the census also, that problem arises. And in the census, if you observe, there is one column after giving 6 major religions, one column is left with the words that no religion stated. So under that column, all these persons, whoever are saying that they have no religious practice, they are giving under that column, they are counting and enumerating under that. But here the problem is, he is stating that he has no religion. It's not that he has not stated any religion, or the stated religion is not under the before 6 columns. The 7th column is given for that purpose. So it's a problem, legal problem. Then we filed a bill before High Court, and while we are approaching, we have categorically stated that the girl who is a minor, till she attains 18 years, she will be, we are the guardian. So we want to bring up her without any religious influences on her. And after 18 years, it is her choice. That also stated in the affidavit. She can go back to any religious of her choice. And we also stated that we are not against, because when we filed this writ petition, giving so many reasons and grounds, because every politician says that we want to end up religious differences and caste must go, all that they give speeches, but when it comes to practice, there is no such provision to give up the religion or caste. It haunts you everywhere for different reasons. Even for who want to voluntarily renounce their religion or caste, they are not given that opportunity. So that, as a case, when we raised seeking a column, to provide a column in all the official records as an identity, no religion, no caste, NRNC, we named it NRNC, as a direction to all the departments wherever this is being registered. Interestingly, the counter filed by the state, we have made the parties as a central government also, union, because census as a party, where they also, they raised this point that we have provided a column, which we denied that column will not suit to me. And the state government, several departments we made them as parties, but they never chosen to file any counter. Only when it came to final hearing, then they filed a counter saying that we have collecting the data of religion or particular caste only to give the social benefit of reservation facility. So here I have stated in the affidavit, voluntarily we are renouncing, even the reservation facility also we are foregoing. Despite of that, when they are insisting that this is for a purpose we have created, so they have to write. Or they said that they can, if they want, we will give that, we note it. But in practice, now, because all this has become in an electronic system, because when I filed this petition, it came to final hearing after 7 years, almost 10 years. And the girl has reached 10th class. In the 10th class hall ticket, it is not a written format. You have to fill it in the, what do you call? So unless you fill, you will not get the hall ticket also. So there again a problem has arisen, and I went to court saying that this is the problem. My identity is being enforced on me. So then the court interestingly said, before the court also we have brought this identity is as old as Hinduism. All the other religions are after Hinduism they have come up. With the population, very less population also, they are being given a column. And the persons who are non-believers are religious people. If they take the census, even as per the census records also, to Jainism and particularly in the state of Andhra Pradesh, there are more number of people than Jainism practitioners. So you are denying a fundamental right for me of my identity, and you are giving a enforced identity to me. So that when we brought before the court and giving the data of outside India, this is not being in India we are practicing, but when we go and look at around the world, irreligion, they do not have caste, we all know, but religion, religious practice, religious people they call. That when they are enumerated in the world, after Christianity and Islam, the third largest population is religious. But that such a big identity outside India is not being recognized, and I have to fight for a 10 years long battle in the courts of law. And ultimately, when final hearing is going on, judge asked me, how many people are there with this prayer? So I cannot give the data because I approached by way of a bill seeking there are so many people and have given the data also. Then the judge has, in view of the counter filed by the respondent saying that they have no objection to record your religion as no caste, and in view of the fact that you have not brought with any data, you have not quantified how many people are asking. Since it is a pill, we are not dismissing your case, we are not allowing your prayer also. So I am disposing with this accusation, is what they said. But immediately after this has happened in October of last year, and immediately after the next month, in November, Telangana government, first time in India, they have given a call and they have put into practice that caste enumeration they started. In that, then we got an opportunity to raise this issue because our bill is disposed with an observation that quantified number is, it is not quantified, so we are unable to pass orders. Now an opportunity is given by the state of Telangana. Since you are enumerating the caste census, you give this recognition of no caste, no religion people also. We got the order on the same day because the next day onwards, it has started in the month of November. We got the order, and in the enumeration, which census went on, this column is created. No religion, no caste. His column is provided, is what we were succeeded. And for the first time, Telangana government has enumerated how many people in India are there, in Telangana are there without religious practice. Is what this is. Though it is it is also an identity, and their dignity is identified with their identity, which is being denied in all the other states. And I came to know in Madras, and High Court has recently given an order like this. I am unable to bring before the court. The court has specific orders. Can you show any orders? Yes, there are no any similar orders so far. There are no precedents. But with this I came before this court. This court can pass, is what I thought. But anyhow, I got the order before a single bench. I did not get the order in pill. But again, Koloni Nirmula Sangam, with which in view of the government of Telangana's initiation, we were able to do that in success. We successfully got that. And moving on to identity of, because Naturally, two lawyers argue before the judge. Now here two judges are there, and I'm one lawyer standing before you. But going to in the magistrate courts, so I want to so this because so much is discussion regarding the lower court practice is also taken. Other two speakers have spoke. But my question here is the magistrate in a case where 153 A IPC is the offence with which Usmania students were taken into custody and produced before a magistrate. The magistrate who has remanded them, when I filed a bail petition, because bail can be granted by the magistrate, he refused to take my bail petition, saying that this is not a special court. This offence can be has to come before a special magistrate court. He is not available. So, as an in-charge magistrate, I am doing this. I can only remand. I will not do that. Then I question that under 153A, and the case is there, if you are able to remand, you can also grant bail also. Then the judge, of course, he sent back the case to the original magistrate, who the next day we got the bail also. But here my question is, the magistrate who are entrusted with any in-charge responsibility, they will get that full responsibility, and they have to do that. And such things we come across, and of course, I have to now share with you another case of UPA case, where here comes of course, we have to see this, all these are as part of rights of prisoners, and their rights to be honored as per law. In Mancherial, Chennur Magistrate Court, in a UPA case, a couple of 70 years and 65 years old, a couple were granted bail by the magistrate when charge sheet is not filed under UPA within 90 days. But immediately on the same day, the APP he filed a revision petition before the Sessions Court, saying that it's a UPA case, bail cannot be granted by the magistrate. And no opportunity is given to the PP is also one of the objections, with which the Sessions Court has granted a stay on the order of the bill. And in fact, that matter before the Sessions Court judge, we had to fight for 1 year. For all 1 year, the Sessions judge went on giving dates till the charge sheet is filed. And the next day only, after filing the charge sheet, he has dismissed, he has allowed the revision petition, saying that since the charge sheet is filed and a prima facie case is made out, bail is not being granted. Now we filed the case under 167(2) clause. It comes under CRPC chapter 12. It is not a bail law. It is under the chapter of investigation. So it is within the jurisdiction of any magistrate for any offence to take to use his judicial power and take a decision. When charge sheet is not filed in 90 days, then bail is to be, we all know it is a statutory provision, so bail can be granted. It may be an offence under UPA, but the magistrate has got that power. And at the same time, APP has to file a petition before the magistrate to obtain further time to file his for investigation time, he has to file a petition by an affidavit by the IO. So such is the law. In the UPA also provisions are there. Without all, in the absence of all this, the magistrate is fully empowered to pass bail. Is now what we challenged before the High Court, and High Court has granted that order. And that is how the magistrate level, at the district sessions level, the courts and judges are casually, here the magistrate has shown his, he is with the law, but the session judge has interpreted in different way, and he has denied it. And of course, High Court has finally got this order. And I'm moving on to my other cases where, since we are speaking about discussing about the dignity, dignity is not only for persons who are living. Dignity has to be shown, has been shown to the persons who died. But except the state. State, because I am bringing a recent case where a Maoist leader, Nambala Keshav Rao, was killed in an encounter, said to be an encounter, and along with him some 27 persons were killed. But 6 persons' dead bodies were kept there, despite of the near and dear going there to Chhattisgarh from Andhra Pradesh and Telangana to claim the dead bodies. They were not allowed to see the dead body. So without even showing them, postmortem is conducted. Without even allowing them to have a last look, they kept the bodies there. And when we moved the High Court of Andhra Pradesh, High Court has given an order saying, observing that we have no jurisdiction, because the Advocate General of Andhra Pradesh appeared and Advocate General. So in that, the order is basing on the Advocate General statement of Chhattisgarh. We have, after completion of the dead bodies, we will give back. But completion of the postmortem. But the postmortem is completed and dead bodies are not given back to them, and they were cremated on their own, the police. So the person, the near and dear of the family members who went there from Andhra and Hyderabad, Telangana to Chhattisgarh, they were not allowed to see the dead bodies also. But in fact, NHRC has given it detailed guidelines and tradition for centuries together how to respect the dead bodies. Each religion has its own practices are there that is being denied. Of course, obviously, this is the reason why they may be outlawed persons, but law will not be applicable to any person died. Here, I only can say one reason why they have cremated the bodies without even showing them even for once. Because dead body speaks no lies, is what we all know. If they are allowed to see by the near and dear, they may bring the torture marks, or so they want, they may go for a re-postmortem and they may bring the real facts. So the entire story by the police will be defeated. That's the reason why they are not even allowed to show to give the dead bodies, handovering them, or to even to have a last glance. So that is how here, when we are speaking about the dignity at various aspects, this is also one of the issue which I would like to bring to your notice. And in such cases, our legal intervention, we got the order, but that is basing on the statement of the Advocate General, when it is not also respected by the Chhattisgarh government. And when we file the contempt case, interestingly, contempt is closed, saying that we have no power. In fact, for writ petition, he has jurisdiction to deny us to go and approach the High Court of Chhattisgarh. But he cannot do so in a contempt. Having passed an order, you have to either implement the order or call for the explanation why the order is not implemented. But without doing all this, the case is in fact closed there, and we are, of course, we are trying our we are taking this to Supreme Court level. And with this, I think now the time seems over. I want to share so many other cases also, but these are some of the aspects as lawyers. when we approach and deal these cases, the real facts, the real way of institutional responses we can see at the police station level, at the court level. All these are all the factors who are the actors who are coming in way of disrespecting or denying the dignity of the persons where we have to fight. Of course, we are fighting. In some of the cases, we are getting orders. In some of cases, we are still fighting. And these kind of interventions will make all of you to know these are the acts, these are the interventions what we have to make. And as a human rights lawyer or a civil rights lawyer, what one has to do, go on fighting and believing that tomorrow we'll get a favorable order. These comments I will come to.
I'm sorry, I'm in the unenviable position of having to stop people who have much to say and much experience to share, and I hope that you will share it over lunch. How far over time are we so that we can take questions, or and of course Judge Nanda is even more disadvantaged because there's no riposte that he could supply. Vasanti, I'm looking at you because you've been glaring at me. Okay, ladies and gentlemen, it depends on how devoted you are to lunch. My colleagues are here. They have much gyan to give you. I will abjure making any remarks except to say that when we are asking, please ask for clarifications at lunch. But right now, does anybody have any suggestions, including my panelists, one suggestion each in 2 lines? How do we ensure that honoring dignity as a habit in the courtroom, in the subordinate courts, how do we extend that habit and make it a space where dignity is respected because procedure is respected? You have given me the problem, many of you with examples, etc., but not the solution. And perhaps someone here of us can bring forward at least short-term solutions. For myself, I will quickly say, I think that the lack of training or the lack of speaking about dignity at the outset, I think is a fundamental flaw in how we are bringing forth judges to come and be, I hate the word sensitization. I don't think anybody needs to be sensitized. That's for their mothers to do. What you have to do is just follow the law.